and that has to deal with the criminalization of the refusal to take a breath test if you're arrested for DWI. It's called State versus Bernard. The Minnesota Supreme Court held you do not have to have, you law enforcement do not have to have a search warrant in order to take somebody's breath analysis if they're arrested, and as such, they upheld the criminalization, the crime that occurs if you say, no, I'm not going to take the test. Other states have ruled differently, but the Bernard case in Minnesota, the Minnesota Supreme Court came down on the side of you can criminalize the decision to not take a breath test, and you do not need a warrant. Somebody asked the United States Supreme Court to take that case directly from the Minnesota Supreme Court, and the court agreed. It's on their docket. I don't know what the scheduling is in terms of oral argument or brief. It's on its way up to a 4-4, potentially 4-4 tie.
And if that happens?
On the U.S. Supreme Court. What happens when there's a 4-4 tie? Nothing. In other words, the U.S. Supreme Court has not issued any opinion on the issue. Whatever the decision was of the lower court is allowed to remain in place for that jurisdiction. And so, for example, if the Bernard case, the one from Minnesota, is tied 4-4 by the U.S. Supreme Court, that means in Minnesota you can criminalize the decision to not take a breath test, and law enforcement can continue to not get warrants for breath analysis.